All right, back to that breaking news involving the Supreme Court. The High Court ruling to end affirmative action in college admissions, essentially not being able to use race within the admission process, finding out that UNC Harvard violating the 14th Amendment. I want to bring in Professor Thane Rosenbaum. He's a distinguished professor at Touro University. Thanks so much, Professor, for coming on here, obviously on the heels of this breaking news here on a 6-3 and a 6-2 vote, respectively, North Carolina and Harvard. Talk to us about this, and obviously you being a part of a college as well, understanding the admissions process and how this now could change. How big of a ruling is this, sir?
Well, Sean, it's pretty huge, right? Because remember, it all started with racial quotas. That was the original concept, that you would set aside a number of spots for African Americans to address the history of racial segregation and prejudice. But the Supreme Court eventually struck that down and said that clearly violates the 14th Amendment Equal Protection Clause, because you're literally saying we're creating these spots. So what happened instead is the Supreme Court concluded that there is something called diversity of the student body that is enhanced by having all kinds of people. And what they were saying, that includes hockey players and musicians, right? Even family legacies, right? So the Supreme Court ended up with a kind of resolution by saying affirmative action could apply as a factor in addressing how one achieves diversity. What happened in this case is that the conservative justices on the Supreme Court literally threw up their hands. Justice Thomas said, I don't even know what diversity means. I mean, that I thought was a very telling moment, as if to say, we keep hearing this word diversity, we don't know what it means, and it seems to us like an excuse for racial preferences. And in a colorblind society, we should be racially neutral. In a way, Sean and Emma, they're literally saying, we have no problem with hockey players. We don't have any problems with musicians, because that's not that's a colorblind decision. But in the end, using race as a factor ended up discriminating against Chinese Americans.
Now, essentially with this ruling, the Supreme Court wants to see an even playing field when it comes to applications, that everyone's got the same chance of either getting accepted or getting rejected, unfortunately. Thank you, Professor Thane Rosenbaum. Appreciate you joining us today and your legal analysis on the matter. For more on this conversation, let's welcome in now Alan Dershowitz, Professor Emeritus at Harvard Law. Professor, welcome, and thank you very much. We kind of went through what this ruling means, and I'm wondering if, when it comes to the application process, if a student might mention their race, perhaps, in an admissions essay, would that be allowed based on this recent ruling?
We don't know, of course. This is a ruling that I have sought for the last 50 years. I wrote my first essay against race-based affirmative action, I think in the early 1970s, calling for affirmative action to be based on economic and social and personal characteristics rather than on race and race alone. I think if the school takes race into account, let me give you an example. If you have two people applying, one whose father is a federal judge, mother runs a hedge fund, they went to Exeter and Harvard, and they're black, and he has B+ average and B+ test scores, and that person is competing for admission, and there is a competition for admission, against someone from the Ozarks whose mother died of a fentanyl overdose, whose father is unemployed, and who really made it from the bootstraps and has a slightly higher grade score. Today, many schools would admit the black, rich, benefited athlete over a non-athlete person, applicant, over the poorer white person. That no longer can be taken, can be done. You can't use race alone, but you can use surrogates that sometimes correlate with race. If you were, for example, yourself, subject to discrimination. I was subject to discrimination. I was first in my class at Yale Law School. I got 32 out of 32 rejections from Wall Street law firms, and it wasn't because I didn't dress well. It's because I was Jewish and an Eastern European Jew. So I suffered discrimination, not like, obviously, African Americans suffered discrimination over the years. But those kinds of factors, I'm sure, still can be taken into consideration. The real question is, will universities cheat? Will they just say, look, we have a 13% quota for blacks. We're going to keep the 13% quota. We'll just figure out a way of achieving it differently, not using race, but using other factors. But we're not going to budge on the 13% quota. I think some schools will do that. And will they get caught? That's the question.
All right. Do we have more time or? Okay. Professor Alan Dershowitz joining us live. Thank you so much for weighing in and answering the call here for the breaking news. Appreciate that.